Dave Kimmel. I work here at the State Agriculture Development Committee, which coordinates the New Jersey Agricultural Mediation Program. And as you know, we're doing this training in conjunction with the New Jersey Association of Professional Mediators. And this is part two. Part one was last week, where we talked about the ag mediation program and things to think about and programs that have an impact on those types of cases, like the Right to Farm Act, farmland preservation, USDA cases. And we heard a great presentation about farm transfer and succession issues and cases, and how that may become something that you might be interested in getting more training on and working and supporting as well. But today, we're lucky to have a speaker who helped us out last year also, and he's also on the Ag Mediation Program roster as well as many others, but you might know him. He's on the screen, and his background includes being a member of the roster mediators of the Superior Civil Court, civil, general equity, probate cases, family law cases, U.S. Equal Employment Commission. Let me mute everybody, but Marvin, you can unmute yourself. And the New Jersey Early Intervention System. He's been a accredited mediator for many years through the New Jersey Association of Professional Mediators, a mentor mediator, adjunct professor, director of civil training for NJAPM, and lots of conferences that he's presented at, authored the Mediators Toolbox as well. So let's give a warm virtual welcome to Marvin Schuldiner.
Hello, everybody. Yeah, listen to that introduction. I'm like, wow, maybe I've actually accomplished something as a mediator here. Greetings. I'm actually in the great state of Michigan. So hopefully all of my technology will continue to work here properly. So I've got a few things that I have on plan for today here. One is kind of the annual review of the Uniform Mediation Act, the standards of conduct, the rules that are in the regulations that are specific to the ag program's mediation program. And then recently we had the ABA put out an opinion 518, that deals primarily with attorneys, but I think even the non-attorneys who are here should get some insight out of what the committee who put together that opinion is trying to tell mediators. And then after that, I want to talk about fallacies, logical fallacies, because we see this all the time in our mediations, and if you are better able to identify them, you might be better able to point them out to your clients and have them or sort of be able to counteract them with them, because they can hold up things. And I'm sure all of you have seen some version of this happening in your mediations during your career. So again, thank you all for being here today. It really is great to see so many familiar faces. Give me 1 second here, and I'm going to share the PDF file that I had sent to everybody. And we will go through that.
And I will be sharing by email to the ag mediators these slides after the session too.
Yeah, so everybody should have this. And if you don't get it, let me know. We'll make sure that you get it. And I always find the mediator rules, we'll call it, to be so confusing to mediators who are really supposed to know this. Those of you who are NJAPM members might remember, it was probably about 2 or 3 weeks ago, there was an interesting discussion on one of our listservs about some of the aspects of the Uniform Mediation Act and the court rules, and a lot of confusion, even amongst mediators who are very experienced. So I go through this, with students probably 5 or 6 times a year. So it keeps me up to date on this, and I think it's important to probably for all of you to pull this out a few times a year and kind of take a fresh look at it, because there are lots of things in here that I think people get not only confused on, but they simply don't follow it. So let's first talk about the Uniform Mediation Act. And by the way, if anybody has a question as I'm going through this, just feel free to unmute and ask. Most of you who have ever been in a class with me know I'm pretty informal about how I go through things. So, the Uniform Mediation Act, New Jersey was the third state to pass this act. I think we're up to somewhere around 13 states that have a version of this, plus the District of Columbia. A lot of other states have elements of this. They haven't formally passed it as this act. But this regulates for all mediators, with a few exceptions that are covered in the act, all mediations in New Jersey. Okay, so everybody should really know what's in here, what you're allowed to do, what you're required to do, what rights you have, what rights your parties have. And again, this is not as clear maybe to mediators as it should be. So I'll start with Section 2, which covers the definitions. And there are two of them that I really want to emphasize. One is the definition of a mediation, right? And that is a process in which a mediator facilitates communication and negotiation between parties to assist them in reaching a voluntary agreement regarding their dispute. So this is probably I would define this as a fairly broad definition of mediation. We can define mediation in a lot of different ways. In fact, the commentary that comes along with the UMA has a much more expansive definition. It goes into a lot more detail, but as far as the actual act itself, pretty much what you're working on as a mediator is going to be covered by this. But more specifically, what's covered by some of the elements that we'll talk about a little bit later here in the act are mediation communications. And I think it's really important to understand what a mediation communication is, because this is what's supposed to be kept confidential. This is what is privileged. And it's not everything, but it's pretty expansive definition. So it's a statement, whether verbal or nonverbal, or in a record, that occurs during a mediation or is made for purposes of considering, conducting, participating in, initiating, continuing, or reconvening a mediation or retaining a mediator. So the way I like to interpret this is pretty much any interaction that you have with your client from the first time you have intake with that person all the way through the last interaction that you have with that person. All of those interactions that you have with those clients, those are mediation communications. Okay. Now we'll see some exceptions a little bit later here in the UMA, but that is essentially what is covered in this act, right? And Section 3 goes and talks about the scope of this, right? So pretty much it covers a lot of things, and really probably better to go through the exceptions here. What's not covered, generally speaking, are things dealing with minors and things dealing with organized labor. So you'll see PERC in here, and I think the State Board of Mediation are also accepted in here. But pretty much it covers a lot of what we do as mediators, right? So now let's get on to Section 4, and this talks about privilege, okay? And here's, I think, another area of confusion that I see among mediators is that they conflate privilege with confidentiality. They are not the same thing, okay? Privilege means that the protected information, in our context, that would be the mediation communication, that can't be disclosed or used in a further hearing, whether that's by, in most cases, it would be through a court, but it could also be through an arbitration. So that's in place so that parties can openly speak with you and not worry that, oh, what you said in mediation will be used at a hearing later, um, or at some sort of trial, right? So um, that's the point of privilege, right? Confidentiality, which we're going to get to a little bit later in the UMA, I think that's section 9 or 10, um, really gets to the parties not talking to anybody outside the mediation about what happened inside the mediation, right? So it's a little bit different. And as we'll see, privilege is given to you here in law, and it's also been harmonized as a rule of evidence in the New Jersey Court Rules, which is 519, which I've also put in here. So you'll have that as well, but it's basically matching the language here. But the interesting thing about the privilege for mediators is that if you think about most typical privileges that exist in the legal world, it's usually the recipient of a service that holds that privilege. In other words, the recipient can prevent um, the provider of that information, prevent that person from testifying. In other words, they're asserting that privilege, right? So most people would think about the attorney-client privilege. So the client, the recipient of the service, is the one who holds the privilege and can say that their lawyer cannot testify about anything that was said between the attorney and the client. Same would go for doctor patient, um, clergy penitent, and so on, right? The mediation privilege is a little bit different because we don't have just two parties here, right? We have the mediator, we have at least two parties who are who you're mediating between, right? Might be more than those just those two. You might have non-party participants in your mediation, and each of those have a different level of privilege that they are allowed to do. Okay, so let's start with the mediation parties, right? So the actual litigants, we'll call them. Um, they pretty much have the most powerful um, of the privileges here. So they can refuse to disclose any mediation communication, but they can also prevent any other person who is in the mediation from disclosing any mediation communication, right? So they can say, I'm not saying anything, and they can say, neither's anybody else. That's the privilege that they hold. Now, you might think you hold the same privilege, you don't. So the mediator and a non-party participant actually have similar, well, basically it's the same privilege. So what you can do as the mediator is you can refuse to disclose a mediator communication, but you only get to prevent other people from disclosing your own mediation communication. So you can't tell the parties you can't testify. All you can say is you can't say anything that I said in here, and you can also refuse to testify as well. So, and then, like I said, the non-party participant, they also hold that same privilege for themselves, right? So, yeah, I think a lot of mediators really think, well, I can just tell the judge, well, I'm refusing to allow anybody to testify in my mediation. You just simply don't have that level of privilege here, okay? Um, Also, keep in mind that there are exceptions to some of these things, right? And you'll find that in section 6. So, what are some of these exceptions to privilege? So, if there is an agreement that comes out of your mediation that is evidenced by records signed by all of the parties to the agreement, that is not privileged. So, those of you who remember the Willingboro Mall case, which is really kind of a landmark case in New Jersey for what we as mediators are supposed to do to have an enforceable agreement come out of the mediation. This was what the court relied on when they wrote their opinion, that if you want to have an enforceable agreement, it needs to be done in writing and executed by all the parties. Okay. The court doesn't want to sit around and figure out, okay, should we be, to figure out if there was an agreement, should we be sitting here putting holes in privilege to find out what happened in the mediation to see if there was an agreement? Justice Alban, in writing his opinion, basically said, look, there's a very clear exception in the law. Follow the law. That's it, right? So now that doesn't mean the parties can't make elements of that agreement confidential. It's just that if one side wants to enforce it, this is the way, this is the method that the court has said you need to use to enforce this. Um, some other exceptions, if a party in your mediation makes a threat or statement of a plan to inflict bodily injury or to commit a crime, um, privilege will go away if that happens. Also intentionally, we jokingly call this the Sopranos exception. You can't use the mediation to the privilege around the mediation to plan a crime, attempt to commit a crime, or conceal an ongoing crime or ongoing criminal activity. So, if somebody admits in your mediation that they committed tax fraud, like they didn't file taxes or they purposely lied on their taxes, um, I don't think that admission in your mediation would be excluded from privilege. They wouldn't be able to use privilege to keep that out, right? If there's a complaint against you as a mediator, guess what? That element of that would not be privileged. Um, And then the same thing if there's really, I guess, in most of these cases, it would be a claim of malpractice against one of the attorneys who is in your mediation. That would also not be privileged. Um, and then, of course, as I think everybody here knows, in New Jersey, every person is a mandatory reporter of child abuse and neglect. And if you have a reasonable suspicion in your mediation that that has happened, again, that would not be privileged. So um, now, how does the court determine whether something should be privileged or not if there's some sort of question? Well, that's what B covers here. Um, so what's supposed to happen is there's supposed to be a balancing test, right? And a judge would, in private, in camera, right, take a look at the evidence that a party would want to have admitted from the mediation and balance the need for the confidentiality and privilege that we have in the mediation against the need for that information to be um, usable in some sort of hearing. And I'll go to another one of our um, landmark cases that we have, which is State versus Williams, where Williams wanted to use some things from a mediation that would have been privileged, and our New Jersey Supreme Court ruled that they were not going to waive the privilege. So the courts in New Jersey have really come down with strong protections for mediation, but you need to know about them to be able to use them, right? Um, so, any questions about privilege? All right, so let's move on to what are you allowed to report coming out of your mediation, right?
Mark, I'm sorry,
So,
Mark, can I ask you a question quick?
of
Um,
course.
Now that with Zoom, right? How do you, I know I observed one of your mediations, you were really good with this. How do you ensure there's no one else behind the camera?
Yeah, a couple. I think there are a couple things you can do. One is get the party to, affirm, attest, swear, whatever word you want to use, that they're alone and nobody else is in the room with them. Um, in arbitrations, it's a little more strict, and I've gone as far as having people take their camera and pan the entire room to make sure that there's nobody there. I mean,
No,
ultimately,
I saw you do that with the car, that mediation. You made everyone look at the car, you kicked people out of the car.
yeah. No, I mean, people need to understand that they're going to end up waiving privilege if they don't keep things confidential to begin with. So all you can do is do your best. I mean, there's pretty much no way to determine whether somebody is actually, if you're on Zoom, let's say, whether somebody is recording that, whether recording the mediation. And it's even if you're in person. I mean, everybody walks in. Everybody has a cell phone these days. They all record, certainly audio and video. It's always concerned me. You walk in there and people put their cell phones on the table, and you have no idea whether they're recording or not. So all you can do is basically insist to people that they follow the rules, that the rules are there for their protection as well as yours, and hope that they do the right thing. But if they don't, and later on they try to have something admitted into evidence, you need to assert your privilege. And that was another thing. Another one of the findings that came out of the Willingboro Mall case was the party that ultimately asserted their privilege did it way too late. I mean, by the time they asserted it, they were already at appellate division, and they should have asserted it at the time that the trial judge was holding the hearings as to whether there was an agreement or not. So don't sit on your rights, don't sit on your privilege. You need to affirmatively assert it at the time that it needs to be asserted. Otherwise, it may be deemed to have been waived. So that's another thing to think about. Any other questions before I move on? Okay. So let me talk in section 7. What are you allowed to tell essentially the people who assigned you to the mediation? So
I have a quick question, Marv, before I was trying to get my mic going.
Sure.
How do you is that in every situation, are you going to get notice that what you've that notice to assert your privilege? Or is it just going to happen and you're going to, I don't know, after, you know what I'm saying? Like, how does it work procedurally?
I know exactly what you're saying. And, sometimes you don't know. I mean, I had a case where I was doing a lot of case management work. Again, all of that should be privileged. And one of the attorneys, the attorneys were fighting, and they had a hearing in front of the judge. And one of the two attorneys basically said a whole bunch of things that I had said during the case management phase of that mediation. And once I found out about it, I sent a letter to the judge and both parties saying this was inappropriate, this should not be admissible, and I'm asserting my privilege. So as soon as I knew about it, I put it out there. I mean, obviously, if you don't know about it, there's no way that you can do anything about it because you don't know about it. And if you did know about it and you didn't know about it, you should be playing the lottery, not being a mediator, right? So.
But that's good to know that, as soon as you did, that was the procedure you took. And did you hear anything from it, or it just went into the dark hole of you did what you had to do and hopefully that's it?
In that case, it went into the dark hole, and I think shortly thereafter the case got dismissed on some motion. So I didn't even.
Okay, very good.
There was nothing going on further, but I've been subpoenaed.
Oh.
And I've told the story many, many times. But I got subpoenaed. What's that?
I haven't heard it yet, Marv.
Okay, well, for those of you who haven't, I got subpoenaed. There was I had a case a good number of years ago at this point where we had come to a settlement with some of the parties, but not all of the parties. And one of the lawyers wrote up that settlement agreement. The mistake I made was I should have read it because the way he wrote it there was some ambiguity as to who was actually dismissed from the case. And apparently what had happened was they filed cross motions for the interpretation, to enforce each party's interpretation of what that agreement said, right? And apparently the judge said, well, since the only one who really knows what happened is the mediator, why don't we get him in here? So I got a subpoena and I got it quashed. Didn't take much to get it quashed, to be honest, but it can happen to anybody. But just again, make sure you assert your rights when at the time that you should be asserting it. Don't wait and till the cows are out of the barn and then you got to go get them back, right? That's not good. All right, any other questions before I continue? All right, so section 7, again, this is what you're allowed or really not allowed to tell, if it's a court or even if it's the ag program, what you're allowed to tell. So basically, you can basically disclose whether the mediation occurred or has terminated, whether a settlement was reached, and who attended. Okay. So basically, you should not be telling. I mean, obviously, if it was an agreement, then that's one thing because again, that's not privileged. But you really shouldn't be telling outside parties what happened. And again, if this was sent to you by a court or an administrative agency, what the UMA says is that you can tell them essentially the status of the mediation, whether it happened, it's done, and whether you reached a settlement and who was there, right? So let's move on to confidentiality. So again, with confidentiality, we are really talking here about what parties can tell anybody who's outside the mediation. So whereas the privilege is a creation of law, confidentiality is, generally speaking, a creation of agreement by the parties. Because, and I'm going to read exactly what it says here, unless made during a session of a mediation which is open or required by law to be open to the public, mediation communications are confidential to the extent agreed by the parties or provided by other law or rule of the state. Okay. Now we'll talk a little bit on the standards of conduct, some of the things that apply to you, maybe not the parties. But I hear so many mediators, both who are my students and not my students, say in their opening statement, everything you say in here is confidential. Okay, that may or may not be true. And what we're about to discover here, there are exceptions to confidentiality as well, right? Same sort of things that apply, the exceptions that apply in the privilege essentially apply here in confidentiality as well, right? So keep in mind it's not automatic confidentiality. Now there are rules, and we'll go through the ag regulations here as well this morning. So some of this is covered by regulation or if you're doing a court annexed mediation, Rule 1:40 provides for this confidentiality. But if you're doing a private one, if you don't have anything in your agreement to mediate, or you don't at least talk verbally with the parties. I mean, it doesn't necessarily need to be in writing, but everybody needs to be on the same page as to what is confidential or do you have confidentiality. So again, keep that in mind. The next section does talk about the fact that you have an affirmative and ongoing obligation to search for and disclose any conflicts of interest. And I tend to be pretty strict with this for myself. I follow the arbitrator's maxim of if there's any question, there's no question you disclose. I can probably count on one hand in the 22 years that I've been mediating how many times I've disclosed something and a party has said, yeah, I think we need to find somebody else. Most times they don't care, but I think it's really all about the perception that you might have been hiding something by not disclosing it. So again, if there's any question whether you should disclose it or not, there should be no question, just disclose it. Okay. Section 10, another somewhat confused section of the UMA. So what Section 10 allows you to do is, or allows a party to do, is have a designated individual accompany them to the mediation. Normally that would be their attorney, right? But there's nothing to prevent them from not having an attorney, let's say, and bringing a parent or a spouse or a child or a business partner or a close friend. They, under the UMA, are allowed to bring, usually it's called a support person. It doesn't say that specifically here in the UMA, but that's the general concept here, is that they can bring somebody. Now, under the court rules, um, pretty much you and all the other parties have the right to veto anybody who's not an attorney representing that party from participating in a court annexed mediation. But doesn't prevent you from maybe having them participating in a caucus session where they're not all together and that kind of stuff. So, um, but people are allowed to bring a person with them. I tend to I tend to look at it as, if the person's going to be helpful, let's have them there, and I'll talk to the other side. I look to her to be helpful. I've had people come into my mediations as a support person and be disruptive. I usually give them a warning or two before I toss them out of the mediation. But look, it's up to you, and what you're doing with the mediation is trying to set an environment that's most conducive to helping the parties get to a resolution. So if that support person is important to get to that, then talk to the parties about the reason as to why they should be there in your mediation. Um, and sometimes, and we've all seen this, right, where the named litigant, or maybe in ag terms, maybe the landowner, um, while their name is on the title, they may not be the ultimate decision maker. It may be a spouse, parent, child. We've all had parties where, oh, I need to rely on this other party. So having them in there, I think, makes the process go a little bit better. And then I think most of the rest of this is just more a little technical in nature. So not really anything that you probably need to worry about too much. So that's the UMA. In fact, the I should just say that the argument, or not argument, but the discussion we had on the listserv a few weeks ago did involve whether a support person could be in the mediation or not. So again, I think it's important to really understand what's in here and what your rights are, what the rights of your parties are, and you've also got the obligation for disclosure of conflict of interest. So, any questions about the UMA before I move on to standards of conduct? All right. So, like I said,
I have a
yeah, go ahead.
question. It's Melanie. I'm just wondering, I had some incidences in the court annex cases where I sent my communications and like one party just never responded. So, I tried, I think, 3 attempts. In that instance, would you say to the court, the mediation didn't take place? Or would you say the mediation didn't take place because I made 3 communications and one party never responded?
I wish I could say that that's a rare event, but that does happen.
I'm sure it does, and that's what I'm just wondering what other people are doing. Because if you read the rule technically, I mean, this is kind of a practical question. It just says you can disclose that the mediation doesn't take place. Just as an aside, I think under the New York commercial division rules, it says something like, the party has to participate in good faith, right, for a presumptive mediation. And so therefore, under their rules, I think it's fair to say someone just didn't show up, right? But here, the way the rule is written, it looks like you're not technically even supposed to say that. But I'm just wondering, in the court administration, I thought maybe you would be a little bit more familiar with like what the how does that work if one party is just not responding at all?
Yeah, so unfortunately, the New Jersey Superior Court does not tend to back their own order to go to mediation. So if you told the CDR point person in most counties, not all of our 21 counties do it exactly the same, but if you told most of them, hey, I'm having a hard time getting one of the parties to engage in the mediation, what do you want me to do? Most often, my experience is that they'll just say, send the case back as unable to mediate. And that's what they do because the judges just don't enforce their own orders. I would not say, the defendant didn't show up on the calls, or the defendant didn't show up at the mediation, or, I wouldn't throw a specific party under the bus. You could just say, I've had a difficult time getting one of the parties to participate. Don't mention who it is. The reality is, at some point, as their case moves forward, they're going to go to a case management conference with a judge, and the judge is going to say, well, what happened with the mediation? And the party that did show up is probably going to throw the other party under the bus at that point, right? So, I don't think you want to leave yourself in a position where you've alienated one of the parties by saying, well, the defendant didn't show up. And now you're going to have a difficult time if the judge basically later on says, hey, I ordered you to mediation. You need to get your backsides in the mediation. That you've kind of ruined your impartiality or neutrality, depending on how you want to look at it. So that's what I would do. I mean, I would just say one of the parties didn't show up. That way you're off the hook for not having followed the order. So,
Marv, are you able to actually write that on the completion form? My understanding was you really can't do anything but check off one of those boxes that's on the completion.
The only thing I would recommend to you ever, other than checking a box on the form and obviously filling out the docket number and caption, the only thing you should ever write on the form is the box that says resolved in part. You kind of need to let the court know, well, it was resolved for this party. So, they don't have to do with the party, right? So it was resolved as to this party or this cause of action, right? Other than that, I don't think you should be doing anything other than checking a box on that form. I might put it in I might just call the CDR point person or put it in the cover email that goes along with the form, that I attach the form to. So, but like I said, the less you say to the court, the better it's for you and everybody else.
Marv?
Yeah.
Marv, John Harper, I want to share with you an experience. As you know, I'm a retired Superior Court judge and have been doing mediation for a number of years, as you have. With the court program, one of the things I think that I found is when a party doesn't show up and appear for the mediation after it's been ordered by the court, I have seen attorneys file an application in aid of litigants' rights and bring the matter before the court on motion in that fashion. In that way, they let the court know of the status of the matter, that one party has failed to appear or how many parties, and the court will then give them direction and can order that that person appear. However, in the court rule, as you probably know, you only have to be there for 1 hour. And that's the frustrating thing, because all you've succeeded in doing is alerting the court to the noncompliance. It doesn't mean that the party effectively is going to achieve anything, because at that point, I don't know how you found it, but in some of the mediations I've had where people have been court referred, I see some people come in looking at watches saying they're only going to be there for an hour because they don't want to pay the mediator. As you know, you're obliged under the court program to give 1 free hour in administrative time, preparation, study time, etc., and 1 free hour in direct mediation service. So the court program has its limitations. The other thing I want to say is something that you haven't mentioned, but I think it's very important. Where there is a non-party, It could be even a mentee. I mentor, as perhaps you do, a number of mediators who have gone through the training for the court program. And I get them to sign a form that's developed actually out of the Garibaldi Inn of Court and also, I think, NJAPM. It's a form that is signed by the party who is by the person who's a non-party, let's say not a participant, but a support person. Could even be a mediator mentee. They agree and certify to keep the matter confidential and respect privilege. So that's an important thing to mention, because I think for those persons who attend, and it reinforces what you have in your mediation agreement. I agree with you. You should have the concepts of privilege, confidentiality. All of these things should be mentioned, and for the court program, Evidence Rule 519 as well. But I think you're doing a great job, Marv.
Thanks, Judge Harper. So just to address the 2 points you have, look, if somebody's that resistant to coming into mediation, I'm not sure I see the benefit of forcing them in there. I mean, we have a court order, and I like to look at the court order as kind of a nudge to the parties. Go try this. But if they're that resistant to it, I mean, I don't think you're going to be getting anywhere with them anyways. So let them go on and spend lots of money on whatever litigation process they're going to go through. It's we shouldn't be forcing people into what's supposed to be a largely voluntary process. And to your other comment, I totally agree. I think it's really important to have the non-party participants sign some type of confidentiality agreement. Although technically, under the court rules, they're already bound by Rule 1:40. And even if they don't want to sign it, you should just remind them that in the rules, we have a duty to keep what's said in the mediation confidential. So,
well, Marv, just one point. I like to have the form prepared and signed, make them aware going in, since they are not a party and not an attorney usually. I like to make them aware of how important confidentiality and privilege is. It's merely just to highlight it. And I would agree with you that mediation is a voluntary process, and getting the parties there is half the battle. But once they're there, it doesn't mean they're going to negotiate in good faith.
Well, yeah, and I think that's where the mediator's skill comes in, is to show them, it's like we always say, that free hour is your opportunity to show how you can help them, and if you can help them, they'll want to stay, hopefully, beyond that free hour.
That's right.
So you've got your powers of persuasion to show them how this could be a valuable process for them, and maybe they'll see it that way, or maybe they'll just stick to the guns. I mean, we never ever fully understand what the motivation of a party is, even if they tell us. We don't, I think, totally know that. But yeah, it's always a complicated thing.
Mhm.
That's for sure.
Okay,
Thanks, Judge.
Thank you.
Anybody else? All right, so now I'm going to move on to the standards of conduct. There are, well, in New Jersey, I guess we have three major ones. They're all very, very similar. The three major ones being the one that is promulgated by the court for court-connected programs. The more general one that's really, I guess, international in scope, certainly national in scope, are the ones that are promulgated by by a group put together between the Association for Conflict Resolution, the Dispute Resolution section of the American Bar Association, and the AAA, the American Arbitration Association. Their rules, I think, were put together, or the standards rather, were put together back in the 1990s. They are now undergoing the process of trying to update those rules. Not that I think they need a huge change, but I don't think that the current rules, from the 1990s ever contemplated Zoom mediations and a lot of other things I think that in our society have come to the fore in the last 30 years. So I think it's good that they're at least taking another look at it. Those of you who also do family mediations, there are actually a different set of standards of conduct for family mediators, and the APFM, Association for Professional Family Mediators, they just put out, I think last summer, they put out a draft of updated standards. Those are a little different than civil ones because they have to deal with things like domestic violence, and which, when these standards were put out 30 years ago, probably was a different issue than what we see today. So they did a lot of updating. I think they did a really nice job of updating. I'll be curious to see what they do with regular standards of conduct, and JPM has a standard set of standards of conduct that largely match, again, all of these. So maybe by next year, my presentation to you will be the updated draft standards at that point. So I'm going to go through the court related ones. Again, they match the others for the most part. Very, very minor differences between them. So these standards of conduct really apply to really all, well, in this case, it'd be for court mediators. So if you violated this, it would be the court that would be, I guess, administering them. And if you didn't see, the court recently changed the complaint process against mediators. So if a party has a complaint against you in your duty as a mediator, it only took them, about 18 years, but they finally took into account all of the comments that we made when they first created that process, which was completely backwards. Now they actually have it somewhat right. But if you haven't read those and you're on the court roster, I suggest that you do, just so in case you find yourself in that position one day, you know what the process is and you know how to defend yourself. So I'm not going to go through the definition of what mediation is. I think we all know that. But let's talk about self-determination. And we're going to see this again when I talk about opinion 518. So here, the parties get to determine what the outcome is. I mean, that's basically what self-determination is. Okay. And there are a bunch of things in here I think a lot of mediators kind of miss, because there are things you'll notice there are a lot of shall. That means you have to do these things, right? So you shall proceed with the understanding that the mediation is based on the fundamental principle of self-determination. You shall inform the parties that the mediation is consensual in nature, right? I think a lot of mediators don't do that. But according to the standards of conduct, you're required to do that. That your primary role is to facilitate a voluntary resolution, allowing the parties the opportunity to consider all options for settlement. So you can't force a resolution on the parties. I've seen and heard mediators do that. So again, you need to be facilitative, generally speaking, and make sure that the parties have the option to consider all of the possible settlement options and outcomes. And everything must be done in light of full information. So if a party doesn't have the information to be able to make that settlement decision, then you need to help facilitate getting them that information, assuming it's available. Obviously, we deal a lot in the world of unknowns. Parties may not have all of the information. All you can do is get by with the best you can with the information that you have. But I think it's really important that if the information is available, the parties have an opportunity to get that information. Okay. So that to me is one of the most important pillars. And again, we'll kind of see elements of this when we talk about opinion 518. Well, you're supposed to be impartial.
Marv, if I could ask a question, What do you mean by parties obtaining information from another source?
Well, it could be the opposing party, right? It could be a third party that has information that the parties need to be able to make a settlement decision. So, and you may need to adjourn or recess your mediation so that they can go and get that information. And it's the old the old Ronald Reagan thing: trust but verify, right?
It sounds like you're talking about discovery. And the court referred cases are supposed to proceed separately from formal discovery. So it's kind of a weird balancing act there between what's called information exchange and advising for instance, a non-represented party to go and conduct discovery. It's kind of awkward,
Yeah, well, I don't think you should be managing their discovery for them.
Right.
Information exchange, the question that I ask, what I basically say is, look, discovery is a trial tool, right? It's so you can figure out what information would be available for use at trial. Whereas when I'm talking about information exchange, and that technically it's focused information exchange, right? What information does another party have that you need to be able to make a settlement decision? So I tried not to get them on the discovery path because that's going to not take me to a place for mediation purposes where I want the parties. Where I want the parties is to have enough information to be able to make that settlement decision. So, and sometimes, my experience, you'll maybe get halfway through a mediation and somebody's like, well, I never got that document. Okay, well, if you need that document to be able to make a settlement decision, well, let's get that document to you, right? Assuming it exists. It is a little bit of a balancing act, but I try and really make a division between discovery and focused information exchange.
Marv,
Yeah.
just one comment on what you said, and that's this, that when you have your initial conference, let's say in a court-ordered mediation, you have a telephonic conference. One of the things you can ask the parties or counsel is, do you have sufficient information so that you can proceed forward with mediation? Because you want to avoid the situation where some things come up in mediation and nobody has the document, because that extends the whole process out, you know?
Yeah, no, and when I do my organizational call, I ask that question: what information does another party have that you need to be able to make settlement? And I asked them for very specifics on that, and then I put that into my confirmation letter, so there's no question. Okay, they asked for it, and I'll have a conversation between the attorneys about, okay, is this something you're able to provide? Are there any issues around it? Just to make sure. But like I said, every once in a while, they don't provide it for whatever reason. They can't find
Right.
it, or
Yeah.
so I do try to make sure the parties are prepared in advance of the mediation.
That's excellent, because I think parties going in and attorneys as well need a comfort level. They need a level to have trust in you as the mediator and also in the process. And they need to be sufficiently informed. So I think that's something that's important to point out to the class, because that information is vital, and it leads to not only what one understands are the facts, but also shaping perceptions, helping people form an impression about the mediation and the trustworthiness of the process.
Agreed, totally.
Yeah.
Can I ask a question? What if like, in like a caucus, it's one party reveals that there's documentation that they don't really want to share? How do you reconcile that as the mediator?
Well, that gets into a little bit of mediation ethics there, certainly. I would explore with that party why they didn't want to share it. Most likely, whatever that document is would be discoverable. If it's material to the dispute, it's going to be discoverable in discovery. So at some point, they're going to need to provide it. Now I've had cases where um, they hadn't done the deposition of the other party yet, and they didn't want to tip their hand on something that they had, and that's why they didn't want me to convey it across. And I said, okay, I understand where you're coming from, but I don't think it's going to settle here today unless you let me convey that information. They never did. And the only thing I could do was go to the other side and kind of do, the old, well, you sure all your documentation is in order? You sure? You're like, really sure? That's all I can do. So, but yeah, I mean, you can't, you can't violate the confidentiality of a party. I mean, what in your specific example, that's not illegal, so it wouldn't fit one of the exceptions. It's just gamesmanship. But you could explore with them. Okay, well, do you think this is really going to help you if you hold on to it down the road, or maybe we'll be able to get a settlement here today? I mean, that's I think all you can do with it. All right, so moving on. I'm not going to spend a lot of time on impartiality. I think everybody knows you need to be impartial. Conflicts of interest. So again, you have to you must disclose all actual or potential conflicts of interest that you know about, and you do have an ongoing obligation. So if you find out something later on, you're obligated to disclose that at that point, even if it means you're going to get dismissed from the case. Again, avoiding conflicts of interest if you're recommending other professionals to do services for the parties. Your best bet is to basically, and what I do, like for attorney referrals, I'll give them a list of 5, 6, 7 attorneys in their area or in that specialty, so that I'm not recommending one person. Related and unrelated matters. Again, you probably shouldn't be going into business with your client shortly after the mediation ends. When I say going into business, that means doing a transaction with them, starting a company, because most conflicts of interest aren't necessarily, particularly mediation, aren't necessarily about the conflict. It's about the perception that the parties might have that you haven't done something right. So always kind of be aware of that, right? Competence. So when you accept a case, you are essentially certifying to the party that you have the necessary skills and qualifications to meet the reasonable expectation of the parties, not your expectation, their expectation. So, if you take a case that's, let's say, a SEPA case, and you don't even know what SEPA stands for, you're probably not going to be able to meet the reasonable expectation of the parties. Okay. So you should not be taking those cases. So make sure that you have the requisite competence to take that case. Confidentiality. So I said when we were talking through the UMA that I would talk a little bit more about it in the standards of conduct, because this puts additional burdens on you as the mediator, right? So here again, you read this, a mediator shall not disclose any information obtained during the mediation unless the parties expressly consent to such disclosure, or unless disclosure is required by applicable rules or law, right? So now you have an obligation. The parties don't, right? This only applies to you. So you have an obligation to keep what happened in the mediation confidential. And then it goes on and talks about kind of the same thing that's in the UMA about what you're allowed to tell the court, right? So, and then this standard goes on to talk about, that you have to preserve, maintain the confidentiality of all the proceedings. You're required to advise the parties of the rules provisions, and this specifically talking about Rule 1:40. So this is a court case, but probably a good practice for non-court cases too, right? So again, you may want to reach an agreement with what the limits and bounds of that confidentiality and non-disclosure might be. You can read the rest of it. You're required to provide a quality process. So, that means that you're supposed to work within the expectations of the parties, in essence, right? And that they continue to maintain their self-determination. So again, I'm not going to cover this one in detail. Fees for service, basically what it says is your fees need to be reasonable. And obviously, if you're in the ag program here, those are fixed and paid for by the agriculture department. The court has for court cases, they have a whole different set of rules, which is a little beyond the scope of what I want to cover this morning, but I'm always happy to talk about that offline if somebody wants to talk about that. So, and by the way, I should mention in the confidentiality that also applies to caucusing. Okay, so if somebody tells you one of the parties tells you something in confidence in a caucus, unless they release you from that confidentiality, you're really not allowed to tell the other side what happened in that caucus. So, any questions? I know I ran through that quickly. Any questions about the standards of conduct?
Marvin, I just want to jump in real quick and let you know we're at a little 11:04, and just for everyone else, the code for the first code is 9857. So again, that's 9857, and I know Marvin, you have a couple more things you're gonna get to.
Yep, we're gonna roll right on into the administrative code for the ag program, just to cover that real quickly, and then I'll get onto the other things here. So state regulation around the mediation program that David and his crew administer here. You probably should know about that, particularly if you're in the ag program. And again, there are some shalls in here. So obviously it needs to be agreed to by all the parties as to when it's going to be held. You are required to commence with an opening statement describing the purpose and the procedures for the process, right? So you're informing the parties as to what's going on, and it's not optional. It's a shall, right? C talks, you can hold joint sessions or caucuses. So you can handle the mediation in the way that you feel best. D does provide for absolute confidentiality within an ag mediation. So all statements made during the mediation process are also deemed to be privileged and admissible for any purpose in any proceeding, unless the parties agree to that it can be divulged. So the ag regulations do provide for very strict confidentiality. The parties can't record it, neither can you. And then some things that are really good practices, even for other things. You shouldn't be providing legal or other advice to the parties in your mediation, or enter into an arrangement where you're going to be providing services to them, other than obviously being the mediator. You shouldn't be accepting any gifts or asking for any gifts from anybody in your mediation. Again, you shouldn't be disclosing confidential information that you received in your mediation. Basically, what the rest of this says is you shouldn't be gaining any advantage from your role as a mediator. You're there to help the parties, not help yourself, right?
Marv, can I ask a quick question about the legal advice? I've seen this before, and I want to hear your opinion. When in a mediation, and sometimes this happens more with attorney mediators, when they say, if you go before a judge, this is going to happen. Like, how do you navigate that? And is that legal advice? Maybe Judge Harper can expand too.
I'll let Judge Harper jump in after I make a few comments. So first, I think you need to discern between legal education and legal advice, right? So legal education is telling a party what the law says. They may not know, which is perfectly fine. In fact, you might even have an obligation as a mediator to educate somebody on what the law says, particularly if they're not represented by counsel. If you tell them how that law applies to them, then you're stepping over the line into legal advice. And To me, it doesn't matter whether you're a non-attorney or an attorney. You really shouldn't be doing that. If you're not an attorney, that's the unauthorized practice of law potentially, and you can have both criminal and civil penalties by practicing the unauthorized practice of law. For those who are attorneys, you run the risk of having dual representation problems. To me, I would just stay away from that. People, New Jersey has 85,000 attorneys. I don't think it's really all that difficult for somebody to find an attorney to represent them in any of these matters. And if somebody asks me for my legal opinion or how I think this is going to turn out, I basically tell them, look, my opinion is just another opinion. Assuming that there are two attorneys in the room, we already have two esteemed attorneys here who do not agree with each other, and really the only person whose opinion matters is the judge, or if there's a jury involved, be the jury as well. So that's how I handle when somebody asks me for my opinion on how something's going to turn out. I certainly can give them little hints as to how strong or weak I think their case is by the questions I ask them, and with the inflection I may have in my voice, or I may ask, how do you intend to prove this? I'm having a hard time understanding this. Can you please enlighten me? So sometimes you can do that. Judge Harper, I don't know if you have anything you want to add.
I do. I want to add a couple of things. One of the things you mentioned under the standards is you're impartial. And even if you are an attorney mediator, the idea is under the court rules program and others, you're to stay within your lane, which is you're not to breach your neutrality, show any partiality, and providing legal advice is totally inappropriate for a mediator to do with counsel or a party. I think your suggestion is good, that if they need legal advice, they should seek the advice and opinion of a qualified attorney in the area and let it go in that. There is one situation which frankly came up years ago. You may remember this. I used to use it when I taught a program similar to this. And that was where one of the judges, who was very respected in the area, did a lot of arbitration, but also did mediation. And when he was asked actually about something, he saw there was a lack of knowledge on the part of one of the attorneys about a critical case. So what the mediator did, and I don't recommend this because this is very, very uncertain to do, but what he did was he took him into his library and he opened to a case and he just threw it on the desk. Now, I don't suggest that because that's really giving legal advice and representation as a mediator. I wouldn't do it, but I'm just pointing that out, that some people have gone that far to do that. If there is a lack of knowledge or getting to the point where you feel a party is not adequately represented, at least under the court program, you have the ability to terminate the mediation because of an imbalance, a so-called power imbalance. So you have to stay within your lane, be impartial, be neutral.
Sage advice, Judge Harper.
What happens? Can I ask a question of Judge Harper?
Sure, Melanie, go ahead.
I'm just wondering what happens if you know or have strong reason to believe that the law is other than the party thinks. Like, do you ask a question? Would you ever say, have you looked at the case law on that?
I would say this, if I saw what was coming was really an imbalance in terms of lack of information the attorney had, perhaps it's an attorney who's a general practitioner and not in a discrete area like labor or employment and was unaware of the case law, I would take the attorney aside and I would say to the attorney, are you familiar with this, that, or the other thing? not saying what the case stood for, but saying, are you familiar with this area? Because obviously there are going to be some questions coming up. I think Marv's point is a good one about asking questions. You can ask some pointed questions to try to steer people. Your idea is to keep a level playing field. You don't want to have people so outmatched in terms of the information they possess or the skills, because I think under the court program, and it's a very difficult question to answer, frankly, but under the court program, there is that rule that allows you to terminate a mediation if you feel there's a power imbalance or some other factor which is going to produce a result that's perhaps on not a just outcome, or certainly such an unfavorable outcome. You're not there to make the situation worse. You're there to make the situation better and keep them on level, even playing field if you possibly can. So that's a good question. It's a very difficult area to navigate. But I would say always go back and fall back on, you're not allowed to give them legal opinions. You're a neutral, impartial person. Even if you are an attorney mediator, you got to stay in your lane.
Totally agree.
And I would just say one thing, because I know we've got to stay on topic, but just to add a fine point to what the judges just said, I find nearly half the cases I have as a court mediator involve pro se litigants. And that comes with its own set of challenges. And it speaks to what you're talking about, Judge, a perceived imbalance. But that's a whole other conversation. But I just have to say, everything that you've talked about becomes, in my opinion, amplified when one of the disputants happens to be a pro se litigant.
Absolutely. That's the difficulty of dealing with pro ses, because if they know you're a trained lawyer, mediator, they're going to look for advice.
Right.
And you have to be very mindful of that.
Yep.
Yeah. Good point.
Yeah, and the only other thing I would add is I have in the past simply pulled the attorneys into a room and mediated between them. Okay, what statute are you relying on? Why don't you think it applies? What case law are you relying on? Why do you think this fact pattern is different? You know, and just kind of getting them to have a conversation where maybe they better understand each other in terms of a law's applicability. That's something else that you can do if you think that might be helpful.
I think that's an excellent point, Marv. And the other thing I think that's helpful, which you mentioned, is I get permission from the parties to talk to the attorneys privately. I have my own little conference with them at the appropriate time when I feel that we're getting close to impasse and I need to get a further understanding of their perceptions. And I try to effect a settlement, at least preliminarily, by working through the attorneys. It's very effective if you can use that technique. It doesn't work in all cases, but a lot of times you're able to settle cases when you talk to them outside of the presence of the parties.
All right, let me move on because I know we're
I
a
just
little
got to
behind.
add one thing. In our age of technology, I'm seeing pro ses coming in with ChatGPT lawyers. So it's even worse than not being informed. They think that they are sophisticated and they are informed. And they'll even say, oh, well, this is what my lawyer said, or I have to consult with my lawyer. And we know that the lawyer, is AI. So
And there's a lawsuit in Indiana against OpenAI for the unauthorized practice of law for providing legal advice. So it'll be interesting to see how that's going to end up turning out.
I want to make sure we
we'll
get to the
see
rest
how that
of
plays
the
out.
agenda. So let's let Marvin
Okay, this is
continue
great.
and keep going.
All right, so I just want to finish up the regs here. So you have to disclose any conflicts of interest. Again, we've covered that before. Any interim or final agreements have to be reduced to writing and on a form that the SADC uses, and you are supposed to help out with that. And if you don't reach an agreement, you need to submit a notice of termination of mediation on a form that the SADC has. So that's all I have here. Oh, and you can continue a mediation. So if the parties want to come back at a later time or date, maybe they need more information or need time to think about things, we can do that. So, all right. So I think we hopefully have beaten things to death here. Now I want to cover opinion 518. And before I get directly into 518, so 518 covers what attorneys should and shouldn't do when they're acting as a mediator. But I first want to talk about what attorneys can and can't do when they're advocates in the mediation, because there's a little bit of a juxtaposition that 518 makes between those two roles, right? So, and those of you who have taken some of my training, you've seen this slide before. So in New Jersey, RPC 4.1 deals with truthfulness and statements to others. And essentially, when an attorney is representing a client, they are not allowed to make a false statement of material fact or law to a third person. That could be you're the third person, or fail to disclose a material fact when it's necessary to avoid assisting a criminal or fraudulent act by a client, right? And those duties in that rule apply even if compliance requires disclosure of essentially confidential information, okay? Now, the ABA came out with an opinion back in 2006, opinion 439, and what that one said is essentially that while lawyers are required to be essentially truthful and not make a false statement of material fact, they are allowed to engage in puffery, making something seem more than it really exists, and of course, bluffing and those kinds of things. So, and they specifically talk about that it applies to mediation, okay, in opinion 439. So now we move on to opinion 518. I think it came out in October, and I apologize I didn't attach it into the PDF. You can Google it and find it pretty easily. After I read that, the first question that came to my mind is, what problem is this trying to solve, right? Are we looking for a problem to solve? And I don't think that the American Bar Association's ethics committee really is looking for work. So I heard a really good podcast, or maybe it was a YouTube video with Jeff Kitchaven. If you don't know who Jeff Kitchaven is, he is a very high-level mediator. I believe he's in the San Francisco area. And he really broke this down very well. There are a lot of podcasts out there about this. I've listened to a number of them, so hopefully I've distilled it here for you, and you don't have to listen to all of them, but by all means, listen to the ones you want to hear. What he said was that the reasoning behind why the ABA took this up was because, and we're going to put an exception on Judge Harper because he does not do this. But a lot of retired judges, under the guise of what they call mediation, are really not mediating, right? They're all the things we talked about this morning, in the first hour here. They're telling the parties what to do, and they're evaluating cases, or they're being directive, right? And what this is an attempt to make mediation be mediation. So I want you to think about it that way. And I think Jeff Kitchaven's probably on the right track here as to why this actually exists. And as I mentioned before, let me take a step back here. The ABA opinions are not binding on anybody. They're advisory. Okay. So even on attorneys, they're advisory, but they're often just really, really good practices. And in this case, you'll see it's really an interpretation of the model RPCs, which New Jersey largely uses for attorneys. Okay. So if you're not an attorney, doesn't mean you can turn off at this point. Really, these are just good practices for even non-attorney mediators. So I want you to think about it in that sense too, because we're going to get into how does this interplay with some of the standards of conduct and your style of mediation? Because as you might be able to figure out, this might force you into a certain direction. So what 518 does is it requires attorney mediators to clearly explain the difference between the role of a counsel and the role of a mediator. And that's contained within RPC 2.4b. Okay. And New Jersey has adopted that from the model standards. So if you're practicing law in New Jersey, this applies to you. And it suggests that you should have a discussion, particularly with non-sophisticated clients, about what the role of the attorney mediator is. And it even goes as far as saying that if you don't think the party understands what exactly your role is, you're required to go back and re-explain to them again. Okay. The and we were talking about pro se's, they come in and they think all of us, even the non-attorney mediators, that we're some authority, right? That we have some knowledge that they don't, and that the words that we speak should be given some additional weight. So think about it that way in some regards. Really, you need to make sure that if you're an attorney mediator, that you really make sure that the party understands that that this is not an attorney-client relationship. Okay. The other thing that 518 talks about is honesty as being an intermediary. Okay. And that an attorney mediator, and again, I think this is good practice for non-attorney mediators as well, that you should refrain from vouching for statements that a party makes, and this is really talking about caucusing, right? As you're going back and forth, you shouldn't be vouching for a statement by a party that you know or should reasonably know is false, okay? And that comes under RPC 8.4C. RPC 8.4 are the prohibited things that lawyers are prohibited from doing, right? It also says in 518 that you should not be advising the parties about what's in their best interests, okay? You don't know what their best interests are, right? They may have told you some things, but most of them are not telling you everything, right? So don't tell them what's in their best interest, but you can talk about what their interests are and let them figure it out, right? So that's perfectly permissible. If you tend to practice a more evaluative style of evaluation, 518 says it's allowed. However, and I quoted directly from the opinion, a mediator may offer an opinion as to how a tribunal is likely to rule on an issue, but the lawyer mediator should not state or imply that a settlement is in the party's best interest because a tribunal is likely to decide adversely to the party, right? So it's kind of a little bit of a tightrope to walk, where, yeah, you can give your opinion, but yeah, you shouldn't really settle just because things might not go your way. I've asked attorneys, what percent of cases do you win that are the slam dunk, open and shut type of cases? And the answer I get most often is about 70%. So if it's only a 70% win rate on the no-brainer cases, even if you're predicting how something's going to turn out, it's probably somewhere between 50 and 70% what your opinion is going to be. So that's, I think, why you shouldn't tell the parties, well, you should settle because you may lose. You may not lose, right? And you don't want to be guaranteeing to that. 518 also talks about how you are not allowed to engage in puffery regarding the party's settlement positions, because the duty of honesty for a lawyer is governed by RPC 8.4C, which I had covered on the last slide, right? And what that says is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And that Rule 8.4C does not contain a carve out for you being able to engage in puffery in negotiations on behalf of the parties. So they can engage in puffery, you can't. And then if a lawyer mediator is asked whether the other side's bottom line is genuine, you can decline to answer, but you're not allowed to answer that that if you know that it's false, or you should reasonably know it's false. So, I mean, I wouldn't opine on where the other party's bottom line is or anything like that. And frankly, when somebody tells me what their bottom line is, I don't believe them anyways, because I've had cases where parties say, I'm not going above a certain number, and then you walk in the other room, I'm not going below a certain number, and it settles in between the two numbers. Things change. They're trying to manipulate you too, right? I mean, that's all just part of the game. So, I wouldn't, I don't generally convey bottom lines. I may say something to the effect of, well, I'm not sure there's much further they're willing to go. That's the sense I get from them. Sometimes they'll tell you to walk in there and say, look, this is it. I'm not going any further. Okay, well, you present it as such. So, I mean, if we had more time, we could have a whole discussion around, how 518. So 518 does not talk about the standards of conduct at all. It only really refers to the RPCs, the model RPCs, because that's what the ABA largely administers. But I think there's some interplay here with self-determination. I mean, I think what the intent of 518 is, it's trying to make sure that the parties retain the level of self-determination that they should have, and that a mediator is not coming in and saying, well, you should take this, you should take that, you're going to lose in court, you're going to lose in arbitration, whatever it is. And I think that kind of ties in with impartiality. If you as a mediator are talking about these things, where you're really pounding on a party to take a settlement, it certainly opens up questions as to how impartial you are, at least within the view of that party. So the other thing to think about is your own style of mediation. If you practice something more evaluative or directive, you may need to slightly modify how you do that, right? And I'm not sure acting in a very directive way is a smart way of mediating, but you have to figure out how you want to practice and what works for you. But you always have to remember that at the end of the day, you need to make sure that your parties retain that self-determination to make a decision that's in their best interest.
Marv,
All right. Yeah.
just Marv, if I could comment on one thing. When you're doing a facilitative mediation, let's say you're working under the Supreme Court rules in New Jersey, Superior Court rules, if you reach a point, and I always tell my attorneys and litigants this at the outset of the mediation under the court program, if we reach a point where we're going to be at impasse, I'm allowed to make under that program a mediator's recommendation. And in making a mediator's recommendation, you can step out of the role of facilitator as long as they clearly understand and are seeking your information or advice regarding an evaluation of the outcome. That's important because a mediator's recommendation can be made, it can be accepted or rejected, but it is often, very often, an evaluative tool that is effective. It doesn't settle all cases, but it can help you move a case along, especially where the parties are going to be at impasse and needs some way to get out of the impasse, and that's the mediator's recommendation. So I would just mention that as another tool to have in your toolbox.
Yep. And I think at the annual conference, or I'm sorry, the spring conference, we had a whole session on the mediator's proposal. And I guess at some point that'll get posted. The video will get posted to that. But we did have a really lengthy conversation on the pros and cons of that. So let me move on because I want to cover logical fallacies. Actually, let me just ask, any questions on 518? I know I went through it kind of quickly. All right. So let me talk about logical fallacies, because when we're in a mediation, people are making lots of logical arguments, we'll call it. And I very frequently see logical fallacies in the arguments that are being made. I was really fortunate when I went through engineering school. well, probably 40 years ago at this point. No, 30 years ago, 30 years ago at this point. No, 40 years. The best class I took in all of my undergraduate studies was a class on logic, reasoning, and persuasion. And that class was all about logical fallacies. And if you can help the parties, or you can help pick apart some of their arguments because they're making logical fallacies, it might be helpful. As David mentioned at the beginning when he was going through my bio, I'm an adjunct professor at Montclair State. This last term, I taught a course on negotiation theory and practice. And these slides actually come from the week that I taught logical fallacies. So it's probably longer than I can cover here, but you all have it. You can go through the slides. If you have questions afterwards, you'll know how to get a hold of me. So I'll go through as much of it as I can here today. And there's probably even more fallacies that I didn't even have in here because I didn't want to go with my class for 5 hours on logical fallacies. So why do these matter, right? And I'm looking at negotiation and mediation kind of in the same breath because what we do in mediation is essentially guided negotiation, right? So well, let me slide ahead one slide here and I'll come back to this one. So what is a logical fallacy? It is an error in reasoning, okay? And the argument that somebody is making appears persuasive, but when you really kind of pull it apart, you find that it's flawed. A lot of them are emotionally compelling. So, oh, wow, they make sense on an emotional level. And sometimes people don't realize they're making fallacious arguments. So sometimes it's accidental, but sometimes people are using it in a way that is intentional to mislead other parties. Okay. So let me slide back to this other slide here. So why do they matter in what we do in mediation, right? Well, we're persuading parties, right? But we're doing it under some set of constraints. And when parties are using faulty reasoning, it tends to derail the agreements that you're getting on because now if the other party discovers, oh, wait, that doesn't make any sense, that's a bad argument, the level of trust goes down. And obviously we need trust to be able to help the parties reach a resolution. When parties do make fallacies, it makes the conflict worse because it triggers defensiveness, it reduces trust, and it causes things to move from interests to other things like identity, right? People who are skilled negotiators, like all of us are, we should be able to diagnose these bad arguments pretty quickly and hopefully move beyond them, right? So people use fallacies for a number of different reasons. They're often cognitive shortcuts, right? Our brains often use a lot of shortcuts because your brain actually requires a lot of your body's energy. So the quicker you can make a decision without having to think through a lot of things is probably better for your brain and your body. Sometimes people just get really emotionally invested in the dispute and use these things. You may have, as Judge Harbour mentioned earlier, a power imbalance. So people will use fallacies to try and balance that out. I talked about manipulation already, and look, we don't often have forever to do our mediations. So there are often time pressures to get things done and falls back into that cognitive shortcut issue. So there are 4 categories of logical fallacies. The first one is relevance fallacies. And this is where an argument's premise, hang on, I gotta move this so I can see that, where the argument's premises are not relevant or not relevant to its conclusion, right? So instead of supporting the claim with facts, they rely on things like emotional appeals, personal attacks, or other distractions to try and persuade the other party. Another type is weak induction. So here, this is where the premises, they appear relevant, but they're often insufficient or too weak to support the conclusion that's being drawn from the fallacies. or from the argument, I should say. The last two categories, presumption fallacies. So this is where an argument relies on either unjustified, unstated, or outright false assumptions to reach a conclusion. And then we also have ones that include ambiguity, where the conclusion of an argument being made relies on either shifting, vague, or multiple meanings of a word or grammatical structures, right? And therefore the reasoning becomes flawed. So I'm going to go through some examples of some of these. About 15 minutes here. Okay, so ad hominem, right? This is where somebody's attacking the person, not the argument, right? And there are a few different types here. Abusive, so you might see somebody attacking a party's character, intelligence, appearance. Circumstantial, so this is because a party got ahead because of their circumstances, not because of their actual qualification, right? So he got the job because he knew the boss's son, or, I'm sure there are worse ones you've heard. I'm not really good with Latin, so I'm not going to even try to pronounce that, but it's basically hypocrisy. And this is where a party dismisses an argument because the person making it doesn't practice what they preach, right? So you should give up smoking. Well, why should I listen to you? You're still a smoker yourself, right? It's that kind of thing. So some examples of ad hominem fallacies. Why should we listen to the new CEO's policies? His suits are ugly and don't even fit. You're a junior associate. You don't understand market pricing. Why should I listen to you? You're a smoker too, right? So that was from the last page. The next one is the straw man. And this is simply misrepresenting an opponent's position by arguing against an exaggerated person. So an example here would be, I think we should improve school security. And the response is, I can't believe you want to turn our schools into prison. So they totally took a small thing and turned, the mountain into a molehill into a mountain, right? So how do you identify a straw man fallacy? Usually you'll see some form of extremism, a misquote or something out of context, or something that's just completely made up. And a lot of these, unfortunately, we're starting to see both in our general society and among the political class in our country, right? Where we see these types of fallacies playing out. So another one is appeal to authority, right? Somebody might cite an irrelevant authority or something that just doesn't apply. It's outside the relevant field. I would say, it was one I gave to my class earlier in the spring here, I'm not sure I would really want to follow a lot of what RFK Jr. says on health matters. The man's not a doctor. He's got a brainworm, I think. But yet he has been put in a position of authority to say, vaccines are bad, despite having no science behind what he's arguing. So kind of a problem. Appeal to popularity, right? So this is, the bandwagon effect. So everyone else is doing it. It must be, good. It must be true. I think we hear a lot from politicians these days. Many people say, what does that mean? Many people say, so what? Who cares? Also, misusing social proof. So that's the old, well, if it's on the internet, it must be true, right? Appeal to emotion. So this is where you're using emotions rather than logic, right? And I know even I as a mediator sometimes will appeal to the fear of losing a case, right? So there's no logic involved in it. It's just like, well, do you want to lose? There's a chance that could happen. But some others here, appealing to guilt, pity, flattery. Sometimes you'll have clients that just get angry and hope they get something out of the yelling or pounding the table or, throwing stuff. I'm sure we've all seen that over the course of time. There's also the false dilemma. So this is where only two options are presented, and many other alternatives are not presented. They're just ignored, right? So, this is you need to accept this or we're going to go to trial, right? Or, those of you who remember George W. Bush, you're either with us or against us, right? That was his thing for justifying putting together a coalition to invade Iraq, after September 11th happened. So, false dilemma. Slippery slope. So this is where you predict an extreme outcome, but often there's no support uh, to back it up, right? So this is the molehill turning the molehill into a mountain, right? So if we allow remote work, productivity will collapse. I mean that's what we've been hearing for the last 4 or 5 years. I think most studies show that people are actually more productive working from home than they are working in an office. But more historically, those of you who remember the domino theory, which was, well, if we allow Vietnam to go communist, then so will Cambodia and Laos and Thailand and all of the other countries that surround it. That was the domino theory, and obviously that didn't play out that way for the most part. Obviously, Vietnam went communist, but most of their neighbors did not. They had other problems, but that wasn't what ended up happening. So that was a false argument to justify the Vietnam War back in the 1960s. There's hasty generalization. So now we're on to weak induction, by the way. And this is drawing a conclusion from a small or unrepresentative sample size, right? And you'll often hear this come across as an anecdote rather than actual scientific evidence. So some of the things you might hear, well, we tried that once, it failed, we're never doing that again, right? Um, or actually, this one was true for me. My grandmother used to eat orange marmalade sandwiches every single day, and she lived to be 90 years old. So therefore, you should be eating marmalade sandwiches because it'll help you live to 90 years old. Obviously, that's not true, right? But these hasty generalizations often lead to stereotyping. So it's something to be careful about. False cause. And this is confusing this is confusing correlation and causation, right? So one may have nothing to do with the other. They may have happened at the same time. But if you can't prove that one caused the other, then you have a correlation, not a causation. So an example of that might be after we raised wages, profits fell. Well, you don't know that the raise in wages caused the profits to fall. You could have had lower sales. You could have had other expenses that skyrocketed out of control. I mean, look what's going on today with gas prices and food prices, right? May have nothing to do, again, cause and effect here may not be, or correlation and causation. And often we get superstitions from this, right? That's how we get, baseball players who, well, I always did this before I went to the plate and I got a hit, right? Well, rubbing your bat a certain way probably didn't cause you to get a hit, but people fall for that stuff. Moving on to presumption fallacies. The first one, circular reasoning. So this is where the conclusion becomes embedded in the premise. This contract is unfair because it lacks fairness. Or he's honest because he always tells the truth. And we know he tells the truth because he's honest. So you'll sometimes hear that in arguments that people make to you. There is also the loaded question, right? So this essentially assumes a premise that is either wrong or disputed. The classic one of this is, well, when did you stop beating your wife, right? I mean that's the classic and historic one. Maybe you'll hear, when did you decide to stop negotiating in good faith? That might be one you would hear in your mediation. We've got the red herring, right? So this is where somebody dangles a completely irrelevant issue in front of you. And what this does is it shifts the focus away from what the core dispute is. So some examples of this, ignoring a claim about a mistake by pointing out a different mistake. My wife does this to me all the time. I'll complain about something to her, and then she'll kind of turn it around back on me and say, "Yeah, well, you never do this, or you do this all the time yourself," that kind of thing. And then, well, maybe starting a war to avoid focusing on a scandal, right? I know there was a book about that, and some people would argue that's what's happening today. Um, so, these things do sometimes happen. Suppressed evidence. So this is particularly in legal context, right? Deliberately leaving out known relevant information that would contradict a conclusion. And we see this all the time in our mediations. And then you get the ethical question of, okay, well, if a party's not asking for something that they should be asking for, do you speak up or not? Again, that's something you have to be comfortable with. I don't have an answer for you on that. Sunk cost. So the sunk cost fallacy. So previous investments should not determine future investments, right? So most people would call this throwing good money after bad. So some examples of this: finishing a bad movie. Like if a movie sucks and you're halfway through it, oftentimes people will be like, well, I already spent an hour sitting here. I'll just spend another hour to see the rest of the movie. Why? If it's not, you don't think it's going to get any better, why sit there for the other half of the movie, right? But people think, well, I already invested the time, but that shouldn't be a factor in whether you watch the rest of the movie. Staying in failing relationships is another one. Either continuing to invest or putting more money into a company because, well, they just need another year, they just need another month. I've already spent all this time and effort trying to get this thing to work. Is statistically, I think about 90% of new businesses fail, right? So again, some costs. False equivalence. And this is when two vastly different scenarios or arguments are erroneously portrayed as being equal. And it's usually done by focusing on trivial similarities while ignoring the more substantive differences. More colloquially, I think we would call this comparing apples and oranges. So these are the things like, well, both sides violated the contract. I'm sure you have heard that at least once in a mediation you have done, right? So that's false equivalence. Equivocation. So this is shifting. Now we're getting to ambiguity fallacies. So shifting the meaning of a key term. So and this is just a logical error, right? All trees have bark. Every dog barks, therefore every dog is a tree. Well, okay, we know that's not right. But sometimes people try to push that stuff. There's the next two are kind of opposites of each other. So the first one's division. What is true of the whole must be true of its individual parts, right? So an example of this, the company is successful, so every employee must be highly paid. And then you've got the converse, which is composition. So what is true of the parts must be true of the whole. And every brick in that building is light, so the building must be light, right? And we obviously know that I don't think you can pick up most buildings very easily, even though you can pick up the bricks that made up the building. So actually, I'm surprised I made it through all of them. Spotting fallacies in real time. So these are things you're probably already doing as a mediator, right? You're going to slow down the conversation. You're going to ask clarifying questions, maybe get additional evidence or information, and then you're going to try and refocus the parties on their interests as opposed to the fallacious arguments that they're making. So how do you respond? Well, use curiosity, right? I love asking dumb questions. I'm not understanding this. Help me to understand, right? We all ask neutral questions. We all reflect and restate things. You can try and get more and additional data. There's an open question as far as strategy goes as to whether to use that fallacy to escalate, kind of increase the tension a little bit to maybe get people closer to a settlement. Depends on your style and what you think might be effective with those specific parties. I always like to say there are some parties that need the pat on the back and others that need the kick in the butt. So you got to figure out whether responding to a fallacious argument by saying you're not being serious, why am I dealing with you, and trying to walk out. Sometimes people be like, no, don't leave. I want to get this settled, right? Um, and you may also want to try and determine whether the fallacy that you heard was used intentionally or inadvertently. If you remember back towards the first, second slide in this section, a lot of times it's really done without the knowledge of the person putting forth that argument. They think they're making a good argument. On the other hand, sometimes people are purposely using this to mislead people. So I think that's all I have here. So trying to get done with a few minutes. If anybody has any questions, I can probably handle one or two before I think David has some closing remarks and the final code. So any questions? I know I went through that fast, but if you have questions on it later on, let me know. So David, there's about 5 minutes left, so I guess I'll turn it back to you.
Yep. There was one question in the chat about is there a recording available from the last meeting? I think that would be a better question. I do have a recording. I'm not sure how the New Jersey Association of Professional Mediators is handling that for people that registered, since I recorded it for the Ag Mediator roster in particular. So I'm going to leave that up to the director of the association to answer that question.
And David, we can certainly post that on
Okay.
NJPM's YouTube channel to make it accessible to people. So that shouldn't be a problem.
All right. In that case, the question is answered, and we can do that. Thanks, Marvin.
Sure.
So yeah, really appreciate Marvin sharing his knowledge, experience, insight on all these topics, and that last topic of the logical fallacies that could apply to everyday life, as he referred to in his examples from his own life. So good to keep in mind for all of us. And the second code is 8235. So again, that's 8235. And I'm going to put in the chat the links to the evaluation forms. So just give me a second. Also stopped recording.